on a daily basis. Further from me is Leef, guardian ad litem in our jurisdiction. She is the guardian ad litem in some of the case scenarios that we are going to be using. And I don't know whether you want to brag or hide that I'm the attorney in most of the cases. For the state. Ceri Artzer is next in the middle. She is our representative from the Center for Conflict Resolution. She's a blessing to us. And our judge, Randin, Roland, who took the bench in the spring of 2006. Please join me in making them welcome.
Thank you. Probably about 6 months ago or so, I received a call from Kelly Hoffman saying, hey, we've got this idea. You guys aren't using the pre-permanency hearing or the pre-planning conferences for that first hearing out there. A lot of that's a credit to attorneys and guardian ad litem like Jay and the other parent attorneys we have in the state, where there's a pretty open flow of information between the parties. They're meeting with the parents and the children before we have our first hearing in about 7 to 10 days after removal. So they've got a good idea of what's going on, the services that need to be provided right when they get to the courtroom for the first time. But what we were finding is we were having some issues when we get to be about 12 months down, where we're looking at permanency hearings which are scheduled. And we've got some cases that are probably looking at termination of parental rights. So we actually had a couple cases that were heading there at that time, so I told Kelly, sure, we'll take a try. We had done some pre-hearing conferences with Ceri before we stopped that practice, and I'll tell you the reason we stopped is because Ceri and Jay both came to me in chambers after one and said, this is kind of a waste of time. We've got everybody coming in, we know what the information is, can we look at something different? Well, this was the opportunity that we had. So Kelly developed some protocols that we went over, revised a little bit, and came up with. If anybody doesn't have the protocols in 2 separate case scenarios, just raise your hand. We'll have Charlotte get around and hand those out for you. The scenarios are actual case studies for cases that we've done where we've used this. I'll tell you, it's been extremely successful. These were cases that were probably headed for termination of parental rights at that 12-month time. In meeting, we were able to have all the parties come to agreement, whether that was for a relinquishment or to give additional time, make sure we had set services in place, outline those so the parents and everybody knew what was happening. One of the big concerns, and I heard Charlotte mention it last night to the Chief Justice, was that the state wants to make sure that if they're going to go forward with termination of parental rights, they want to have the evidence. The last thing we want to do is have that type of hearing, terminate parental rights, and then find out 18 to 24 months later that they're getting reversed. That gets tied up on appeal way too long. So, with that, I will turn it over to Ceri Artzer, and she'll go through our protocols, and then we'll turn it over to Jamie.
Thank you for attending. Thank you for allowing us this opportunity as a Cheyenne County team to come and share with you something that we know there are others in this room who have probably utilized this process. If there's anybody in here who this is not really a new concept, can you let us know? We might utilize some of your information. Okay? And if these are being used in your area, that's great. If this is kind of a first time, we want to introduce you to this process. I'm proud to be here today and to be able to give you this. They have scenarios we'll talk about where this has been used. This is kind of the process. You have a protocol in front of you, and this is what we have worked from. So with that protocol in front of you, you'll see that it follows closely with what we're talking about here. When we look at alternative dispute resolution, ADR, we're talking about abuse, neglect cases. There are ways to integrate alternative dispute resolution into the services and the process that court goes through. We have pre-hearing conferences at the protective custody hearing within the first 2 weeks. Some of these are expedited. If children are removed from the home, this usually happens the same week in China. Family group conferencing is something that can be used at all stages. It's also called family group decision making, and we've been able to integrate that in through Department of Human Services. That is a process that has gone on for quite some time. We hope you're familiar with that at this point. Settlement conferences at any stage of the process. Termination of parental rights settlement conferences when the petition has been filed. These are all ways that alternative dispute resolution can be utilized. I happen to be a contract mediator facilitator through the Center for Conflict Resolution, and we may have some of the other centers across Nebraska represented here. We provide this service, and that is how I got in touch with Judge Roland and his team. Do we have some other centers of Nebraska represented here today? Okay.
Concord Center, serves Douglas and Sarpy County.
Okay.
Resolution in Beatrice.
Okay. Northeastern. In Lincoln. Okay. Thank you. The permanency pre-hearing conferences are what we have handed out protocol. They are used normally, required to be held within 12 months of child entering foster care. It's not a standard review hearing. There is a difference. Our judge will be talking about this a little more. The purpose is to determine what the permanency goal will be. If there is a recommendation towards reunification, recommendation toward adoption, or toward guardianship, or in some cases independent living or other, if there's another way to have resolution. This is what is talked about in this permanency pre-hearing conference. The permanency hearing is coming up. The court must make findings as to what reasonable efforts are being made to accomplish the permanency goal. It will be one of four things. If reunification is the goal, what reasonable efforts? We seem to hear a lot about that in this conference. Reasonable efforts are being made to reunify the child with the parent. In the past, the permanency hearings have been treated as review hearings only. Parties may have not submitted the sufficient information so that the judge can make a decision as to what that goal is. So really, the whole goal of these permanency pre-hearing conferences are to get all information to the table in a timely manner, preferably 6 to 8 weeks prior to the permanency hearing. It may happen shorter period of time than that, and that's okay too, but as the way we work with them, a facilitator has a protocol to know which questions to ask, depending on which path we're leading down. Okay. When we bring parties together to gather information and discuss issues so that the court has sufficient detailed information in which to make a decision as to the goal, do you think that's an easy process to get those people together? It may or may not be, but in some cases, when this is a goal, and your system would like to utilize this goal, and to be able to use this process, normally what happens is the date is set by some of the legal parties that are going to be there, the court facilitator, the person such as myself who's invited to come and to do this for them. We agree on a date, and then normally it's just put out there, please be here. And so they attend. The reason for this, it's a very structured process. The neutral party is there. There's no need to have a buy-in by the neutral party. Therefore, that's how the centers across your state have been working with the courts to be able to provide this service. When it's held prior to the permanency hearing, the protocol says 6 to 8 weeks. Our practice could be to have it at least 1 week in advance. Now, in that case, that would be difficult because if we find that there are some stones that haven't been unturned that may be helpful in this process, that may not be a time enough to get things done. We talk about, as you'll see, all the services that have been offered, if some have been court-ordered and not offered or not available. Some of these things could play a big part. So we like to recommend 6 to 8 weeks ahead of time. And who attends? This mirrors a team meeting in some cases. Parents, their attorneys, older youth. We have facilitated where the children are there. We like to give them voice. Caseworker, guardians ad litem, county attorney. That's pretty neat to have them at the table. Relatives, foster parents, family support workers. We've been creative to try to get everybody to attend. We've had people attend by speakerphone. We like to have them sit in an area where they're all facing each other if possible. At that point, it looks like a family group decision-making process where everybody kind of has equal voice. Our family support workers, in many cases, are people who have really been in the home and have been working with these parties for a long, long time. It says the facilitator is important at this stage in the case. There has to be some background of abuse and neglect cases. Timelines for what the courts, all the people involved, the attorneys, everybody's working toward a timely manner in getting this thing done. So I appreciate that I've never been asked to come and facilitate without having been able to review the case ahead of time. Our work in mediation is highly confidential anyway. We review the case prior to that. We just arrive early, basically. I have reviewed the case in another situation where I had a guardian ad litem report. Anything to give background, because it's so important to know their names, to know the birth dates, to know how old these children are, to know the parents' names, so that the facilitator can be a little bit more open with people to gain a trust, hopefully in a situation. You're only going to be all in there for an hour, but to give voice to each and every person there. The person really needs to manage time well. That's always an ongoing challenge, to make sure that everybody has voice, that you can hear from everyone, but also to make, it has to keep moving along. And to be able to really focus on important issues is very primary, because as you'll see, there are specific questions that are asked, and we bring it down to this quickly.
On your facilitator, do you think it's necessary that the facilitator have legal experience, training, or education in the legal intricacies of termination and permanency, as compared to the pre-hearing conference at the 12-month period of time where you're looking at permanency and you're looking at termination? You're coming into some major legal issues, and do you have legal training or legal experience facilitators that are handling that, or is that an issue?
I would assume that the court, the team, would have ideas about that, because in all regards, the mediators, the facilitators that come from the centers, yes, there needs to be some background in that, but actually legal, you would be looking toward maybe attorneys who are the legal, is that correct? To facilitate, or somebody who has been highly trained in the legal system. A retired judge might be somebody who would be asked to facilitate. It doesn't necessarily just need to be a neutral third party coming from the office capacity I can speak to, is being a center trained mediator, trained in family, trained in, different things. I'm not a legal background person.
In response to Judge, I would say, I'm not sure, that's why the attorneys for the parents are there, and the county attorney's there, they know the legal, the mediator is basically go through a process that all the parties who have due respect to be able to speak up and help make their decision. I don't think it's the fact that they would understand that for the termination process legally, everything would be necessary to be a good facilitator.
I appreciate that, because so much of what our past may be is working with families, trying to make sure it's a safe place for people to talk, to converse, to compare notes, to feel like they're heard. And with children and the family and the support workers that are there, and very much so, the guardian ad litem, the attorneys, everybody at the same table with someone who helps the process and the conversation to keep moving forward. And to let them bring out the information that's needed to talk about. That seems to be where we are right now, and they might address that further later. Because like I say, these can mirror team meetings in some manners, right? Very much so. Anything you want to say about that?
Just, I think that in the ones that we have done, there hasn't been any problem with the facilitator not having the legal knowledge because the other attorneys are there. We're very good at asking this beforehand, okay, what's the timeline? What are we looking at? What's the next hearing? What's going to be accomplished at this hearing? So we're all on the same page as far as where we're going. And because we're looking at a progress that takes a couple hours, we're dealing more with specific facts rather than, how is this going to affect the whole line. We all know what the goal is when we're looking at a permanency hearing conference, and the attorneys, I think, give the legal information, which is why it's so important that they be there.
When you look at the protocol and you see the introductions, the explanation of the process, we give a brief overview. And we really like it when we introduce ourselves. We're encouraged, we introduce ourselves as our legal or family relationship to the child. And that's our real first emphasis in this process, to focus on the children. You know, granted, children are out of the home, they're away from their parents. Yes, there's a lot of interest in what the parents are doing, but this is a process to get the shift back over to the kids. So we want to hear about the children. We want to hear, if you're at the table, what your relationship is, either legally or family. We want to help update on children. Do we have, like with older children, possibility of have their wellness checkups been? If they're on medications, are those being in a timely manner? Are things happening in their health and their education? Is school back in session? How are they doing in school? Current placement, we like to hear from foster families, how it's going, what the progress has been, if behavior was an issue, how they're doing. A lot of times there's just a lot of really positive stuff happening right at the beginning. We like to set the tone in a hopefully positive manner. That will give the parents some bit of relief that maybe things are still happening okay even though their children are not there. The services provided, progress made, remaining issues. Sometimes we find out that there have been services that were court-ordered, made available. This synonymously works with that process I mentioned several times, family group conferencing. We try to start those in a very positive manner, talking about family strengths. We always get to the concerns. That's a part of it as well. In this process, some of the concerns could start going out when we talk about progress made. This could be our concerns area that are shared. Remaining issues. It's amazing what comes up. It's just amazing what comes up. And so often, we try very hard to not take a lot of time on this, but we like to uncover the resources that are available. There may be more thoughts about resources that are available. Family members saying, maybe I could do more. Sibling contact and placement. I had one recently where I was thinking this was the only child in the home. I found out there were others who had grown, moved away. This child was grieving that there was not that contact. It wasn't because foster parents weren't trying to help them with that. Sometimes when people live away, it's just so important to find out these things so that everybody knows this child has a need. We try to let the older children talk a lot and to have a voice and tell us what it is that they need and want. And so we get updates on the parents, so we don't by any means disregard what's happening. We want to make sure services that have been provided, there's progress made, issues needing to still be addressed. And this is why the timeliness of this, 6 to 8 weeks ahead of time, could be your best objective. This is when it gets to the discussion of the permanency plan. This is when we allow the Department of Health and Human Services worker to say, what is the department recommendation? And why? Okay, has there been progress made? We'll explore that later, but the remaining parties at that time will have a chance to discuss their agreement or disagreement. We're not trying to get everybody on the same page here necessarily. If they disagree, that's okay. We just want to have some kind of a discussion about the recommendation. This is where a lot of viable information may come out as well. So this is why it's a very structured process, but it has to keep moving along because normally we only have an hour. When we address the permanency plan questions, as you can see on your protocol on the attachment, you can see that there are questions to be asked and answered, hopefully, by the parties based on the recommendation. So if there's only one recommendation, you're only going to zero in on one set of the questions. For example, if reunification, which in many, many cases with the work that is done, is that our hope? If that's our hope, we want to really explore how is this happening? Have conditions leading to the removal been corrected? Why is this plan in the child's best interest? You'll see that question resonating throughout all of this. These are questions that have probably been asked before, but sometimes when you have everybody in the same room together and you're trying to get the very best information you can, that has to be very clear. Child's best interest. How often is visitation occurring and where? What's the date and detailed plan for their return home? If we're going to submit this plan and we're going to talk about it in a group setting, the judge is not present. So how is the court going to receive this information? So that's where your facilitator has to write up a pretty lengthy summarization of what happened this day. And I want you to know that not only do you have the protocol that we've passed out, but you also have on your book here that we've gotten. This is a beautiful summit material book. There's a lot of resources in this book as well, you've probably discovered. Page 62, best practices for permanency planning hearings. These questions are on the protocol, but they're even more lengthy in here. You have a checklist. You can make copies of this. And you can expect these questions to be answered no matter what your position is for this, if you're a guardian ad litem, if you're the county attorney, if you get a copy of the report, the summarization, or if somebody wasn't able to attend and they get a report, that's how we try to get all this on the same page. And ultimately, the county attorney submits it to the judge for his review. And what are plans to continue necessary voluntary services to the family. Sometimes there are a lot of questions. If this happens, are we done? Or what happens? And we'd like to have that information available to us.
I was just curious, do you have any data or statistics that talk about since you started this, how it's made a difference in terms of pregnancy planning for children and how the outcomes have improved?
That's probably the case scenarios, right? And we're going to talk
Like I said,
about
we
that.
just started this about 6 months ago, so we've only done about 3 or 4 of these. The most recent one, I think, was actually Monday morning this past week. I can tell you personally the results that I'm seeing as the judge. I have yet to have a contested permanency hearing. Everybody has come in agreement. We did have one where, as one of your case scenarios, where everyone was in agreement that adoption was going to be the recommendation for permanency. However, how we got there, everybody except the department agreed to voluntary relinquishment. The department was insisting that we have the termination hearing. So if mom has more kids, they don't have to take over children's rights. I can tell you on Tuesday afternoon, the attorney called up. He had just met with his client. The department was no longer objecting. The caseworker went over, went through the form, and brought a report that she voluntarily relinquished. That child had been placed with the foster family since birth. Her sibling was adopted last year. Their adoption is taking place probably for the next 4 years. So we're seeing real efficient results compared to what would have been a termination hearing, would have been tied up on appeal with having doubt from the attorney, rather than waiting 12 to 24 months for that decision.
I just can't emphasize enough trying to get this information in number 4. What's the date and the detailed plan for children's return to home? This is where this really can hit home with mom and dad. If you ever feel like really they're just not in a very cooperative manner, if you feel like some things they've kind of slipped, this does have some accountability built in. And how is this going to look? And what are the plans to continue services as needed? So we tried to really clarify what's still missing, get that down. Then everybody, it's kind of who will do what by when, if we find that case. Anything else? We find out at that time. When we go ahead and end the hearing, we designate the person responsible for getting all of this information to the parties that are released. And we draft a report, we submit it. It's usually been about 2 pages in summarization, but it starts from the child's health. We have a sign-in list of who all is there. They print their name, they sign their name, it's all very official. And once the judge has that report, he hopefully feels like he has got some kind of a case progression, a plan beyond that.
And on that, that's not just given by the county attorney, that's after next year. Our
So family team meetings, when we've had these discussions, is this something else that can be added? I think that neutral party leading the discussion takes pressure off people who have their stake. They are there because they have a job to do. You have a set agenda. The protocol is there. It's permanency is going to be the primary focus, so it makes it pretty streamlined. We have 4 options usually. And then the report being drafted, submitted to the court, conveyed to the judge. I think that is where we are, and we have more to present to you. And I know that there are some other people in this room probably that have facilitated these. I might ask, is there anything you would add or anything you've found that's very effective that we have not covered? We want these to be effective. If we're offering some of this service to you, we want it to matter. Thank you very much. I'll let you go.
conferences on. You can see that I'm looking at case scenario 1. You can see that these are not just, I don't know if there is such a thing as a typical scenario, but these are, we tend to use these mostly with very complicated cases, things that have got unusual situations. On case scenario 1, we had 2 children who came to us from Lincoln's system and had already been in the system for several months before they came to us. When we went to the scheduled adjudication, both parents entered admissions, we started providing services, and our goal was reunification. The jurisdiction wasn't transferred to Cheyenne County, I'm sorry, until October of 2008. And at that point, everybody had new attorneys, new judge, knew everything. It was all brand new to us. But these people had been in the system for since April and didn't come to us till October. So they had already been in for a substantial amount of time and suddenly had a whole new set of people to help them. That's always a challenge. I mean, that kind of switch means that obviously you're not going to be up to date on what's gone into in their lives. They're not going to be up to date on what you want them to do, and it's certainly going to vary. It was a big challenge, and because we had continuing abuse problems, chemical dependency evaluations hadn't yet been done. There were all of these things that were just making this take forever. And in the meantime, we had 2 children who were in the system, out of the parents' home, very difficult. And when we had the permanency pre-hearing conference, it served several purposes. We had everyone there at the table. The children were not, because at that time we were still dealing with fairly young children. Both parents were, however. All of the attorneys were. The county attorney, I believe, was. And this pre-hearing conference was really a chance for us to sit down and, in a very concrete way, make the parents aware of all of the services that the judge was going to see that had been offered to them. I mean, we went through them time by time, and it seemed to make a big difference to the parents to actually be sitting there and hear, this was done, this was done, this was done on these dates. Now when we do team meetings, we go from the last team meeting and say what's happened since then. But then at this pre-permanency conference, to start from the beginning and step it through time by time in a very non-accusatory manner, I think made a difference to the parents. They were more able to see, wow, you know, you really do know what has been available to us. We can't fool you, we can't fool ourselves. There's some real accountability there. For the attorneys, for the parents, it really does give them a way to help their clients come to some realization. You hope that it occurs before then, and that's why in many cases we don't have to use this. But in cases where it's really difficult for the parents to realize where they're at, a pre-permanency hearing conference is just an excellent tool. We also find it very helpful in this case where you have attorneys who, for the parents, want something entirely different than what the state wants, who want something different than what the guardian ad litem might think. It doesn't just help the family make these decisions, it helps the attorneys make these decisions as well, which cuts down substantially on the amount of court time, and because of that, the amount of time that the child is waiting. So it's not just the families that are slowing this process down. Even though we're doing our jobs, it is very much the attorneys that can slow things down. In this particular scenario, I was a guardian ad litem in this case, And my concern was that because we had had so many months in one part of the state, and then a transfer to another part of the state, and really the parents had not done much in the Lincoln case. And it was difficult to decide whether that failure was because of the parents or because of the system. And it was important to me as GAL to make sure that these children were getting every chance to have these parents as their parents, because there was a very strong bond. But it was very important for the state to make sure that these children had some permanency. And through this pre-hearing conference, one of the things that we accomplished was to say, you know, we can't figure out what's going on across the state from all of this convoluted information that we're getting, but we can hold you accountable for these things that have occurred here. And we can very simply state this and this and this need to happen within this timeline. We are now at the end. And it served as a real wake-up call. What we saw was a substantial change in the behavior of the parents and allowed us to really consider reunification. I'd love to say it has a happy ending. I'm not certain that that's true. We did accomplish some major changes in the parents' commitment to becoming clean and sober and to prioritizing what was important in their lives. At this point, the case is still ongoing, and it appears that we may still have some regression. But even if that's true, what we did manage to find was a consensus between everybody that if we can manage to do this, we're going to be a reunited family. And if we cannot manage to do this, then this kinship provider is going to be someone that we can live with as far as still maintaining contact with our children, still being involved in their lives. And it was a solution that I felt was a very appropriate solution for the children and helped the parents have some buy-in to that. So in that regard, I think was successful. Yes?
Looking back at it, what do you wish would have happened differently from the beginning in terms of making the process run smoother or more timely for the children?
Mom and Dad would have stayed in Lancaster County.
And this is one that the permanency hearing did sneak up on us because it had been in Lancaster County for so long and then came to us. I know that I wasn't thinking the timelines went back to when the child was removed. And so it snuck up on us, and we did put on part of the evidence, keep the record open, and then move forward.
7 months later, you know, we get it. I guess the thing that I wish was easier to follow as the GAL, you know, we get so much paperwork, and when a case is transferred, if you get paperwork that's this high and you've got the family who are all giving you different information, there's not really a connection in between. I guess I wish there was some way to have a more neutral view of what happened in this part of the state before it came to us. Because in the end, what we ended up doing was saying, okay, we're only dealing with what we've got here now, and we're going to have to work within that framework in order to be able to make our decisions. Yes?
2 questions. Number 1 was your case, like I think you made the comment towards the end of the comment, facilitated by the fact that you had grandparent foster caregiving. That was very helpful to you.
It was.
The second question I have is, it's particularly important because this came from Lancaster County. Did you have, and you're the guardian ad litem, did you have your 5- and 7-year-old child at the review hearings?
No.
And the permanency hearings?
No.
Because I sat in with those 4 Lancaster County judges, and they require that the children be present at disposition and review hearings, and I assume permanency hearings too. What is your thought on that? And I'd like the judge to comment too, on the propriety of that in this case, because you had a circumstance where you had parents show up drunk at a hearing consensus at that presentation yesterday was that that's good for these children to see their parents that way, because they have this jaded notion that their parents will be doing everything and it's the system's fault and all that. And I don't know how true that is with a 5 and a 7-year-old. I would have been very cautious about having them. And I would probably think you did the right thing, but I'd like to hear your comments and the judge.
In truth, this 5 and 7-year-old have seen their parents drunk all the time. You know, this is nothing new to them. The grandmother in this case protects the children. The parents are around on a daily basis. They suffer with grandma and the kids. They've got a really strong relationship. The fact is the parents have not been able to make it clean. So I guess in this particular case, because I felt like the children weren't going to go through a change, their life was going to stay the same. Grandma was still going to be actively involved, basically the primary caretaker, and the parents were going to continue to be involved on a daily basis. I didn't see that there was going to be any benefit to my children to have them there. You know, the hearing for a 5 and 7-year-old wouldn't have carried a lot of information for them, and because we did this pre-permanency, there wasn't going to be evidence put on it. Instead, I took the opportunity after that to sit down and go, okay, this is what happened, this is what's going to be going on. Pretty much, you're going to be with grandma, mom and dad are still going to be coming in and out. I don't know if it's going to be different where you're going to end up living with just mom and dad. I'm still not sure, but mom and dad are still going to be involved. So for me, because there wasn't going to be a major change in the children's lives, I didn't feel like they needed to be there for that part.
Did you get a waiver from the judge?
I generally do require that the children be present for all hearings.
Unless they could show good cause.
Yeah.
All hearings, first and
All hearings. That doesn't necessarily mean they have to be in the courtroom, especially if it's a case of abuse, but at least they're in the courthouse. I kind of look at the age of 8 as to whether or not they should actually be in the courtroom. There are some things that I would agree with you. I don't think those kids need to hear about mom. And I don't want a lot of dirty trash aired out in front of the kids. I don't think that's healthy. And for this particular case, their age was a big factor. They were having a constant interaction. I think
we could all probably do a better job on these transfer cases, given that our jurisdictions all do things substantially different. And I presume that the Guardian Lion and Lancaster County probably couldn't answer a lot of questions. And I know when we accept transfers, we rarely communicate with the prior jurisdiction, but that may be an easier way to try to get some real-time information as to what had happened in the prior jurisdiction.
I agree. I agree. Yes?
As an experience neutral, I'm having some substantial GERD over the concept of meaningful ADR versus coercive ADR. It takes 20 to 25 minutes just to exchange the warm fuzzies and to try to get a nice fact pattern that everybody can minimally agree on. Then we have some substantive issues, and we're trying to get this all done in an hour. And then the decision that is made is passed to the court for the court's imprimatur that this is exactly what we're doing, and everybody agreed, even though there were major differences. I'm having some real problems saying that you can accomplish all that, or represent that you can accomplish all these things in 1 hour.
Right. I think that the difference is we are not spending 25 minutes on the warm fuzzies. We have a small community, and we have a team meeting every month. So these people that are in this room are not strangers to one another. These people that are in the room have already been meeting on a regular basis every single month. And so we know each other and already have that relationship, including the parents and the foster parents and the grandparents.
I know the big law firms in Omaha, but in federal court, we went a day and a half on mediation. It just sometimes takes that long to get things done. So why going in is the thought that 1 hour is going to cut it?
I don't think that we're limited to that 1 hour. I will tell you that in these particular case scenarios, they took about an hour to an hour and a half. But in these particular instances, the problems that we had weren't how, I mean, by the time you're at pre-permanency, the problem is not what can we do to get us further along, it's what have we done and where are we at. So So I think that that is a less difficult process to get to.
But if you have a child with special needs or a dual diagnosis parent, does an hour give you any significant time to really examine the issues and the needs of the child?
Again, I think that's just the protocol. Ceri can probably just talk more to this. I know the one that they just had on Tuesday went for 2.5 hours. I don't know what the specific results of that were, but I think it's important to set a time frame so everybody understands we have an agenda. I know attorneys are busy, the parents have jobs, they have places to go. Last thing we want to do is tell them that we're going to take a half a day and we're going to talk about all this stuff. Ceri can talk a little bit more about that. I think the fact that you have an agenda, you have a time frame, let's get in, let's get the issues on the table.
Well, I agree, the importance of getting people in the box. You can't get anything done unless you get them in the box. That's lesson number one. However, if it becomes a series of face-off like English wars, we have 9 armies amassed against one, and you're a GAL trying to help the parent when you've got a special education issue significant and you got a dual diagnosis and you're teetering. Do you just simply cave and say, well, it's 9 armies against one, stamp it off, let the judge sign it, it's official?
No, I've never felt that way.
That's
No.
the coercive portion of ADR that really scares me.
I have to hand it to my, my mediator, but I never feel that way. And I've appeared both as attorney for parent in cases where we've had that, and I've appeared as attorney for GAL, for the children. And in no cases have I ever felt like it was a coercion thing. There are times when you walk away and say, this isn't going to be here. No difference. We still go into the permanency hearing and we fight there. I don't have any problem with saying, this isn't what, I can't agree to this. It is not something that's right for my child, or my client isn't being heard here, and so you move on. Mediation of those issues before the permanency plan is just one step.
I understand that they all feed into each other.
I agree, but I'm saying I have no problem with the coercive part of it. That's certainly not what I've experienced through the mediation that we've received. Yes.
These mandatory, we all have the cases where we absolutely know it would be a total waste of time to get together.
No.
So are there cases where the lawyers can say to the judge, we might as well just skip it because this is going to termination, or this is going to progressive permanency?
Absolutely. We only do this on the cases that we believe it can make a difference. And as a matter of fact, we had a couple of cases where we thought it was going to be something that would be helpful. We thought we were at polar opposites, that somebody wasn't going to do what they needed to do. Ended up scheduling the mediation, and when we got there, truthfully, it was a waste of time because we were all there. We were already at the point where it was going to be helpful. But in that particular instance, it didn't take us very long to figure out that was true. We had already reached a consensus, the parents were on board, things were good. Yes, back to that.
Well, I just wanted to clarify, there's no requirement of these pre-hearing conferences to come out with one permanency plan or one goal that everybody has to agree with. The purpose is that we're at the 12-month stage. What issues do we need to talk about? What, based on what do the parties think about what the goal should be, and based on what they think, how are you going to get there? So I think even if there isn't going to be agreement, even at the end of, even at the end of the conference, there may still be a benefit in hearing the other party's side about what they think the permanency goal should be and why, and how they're going to reach those steps.
And as a judge, the best thing I like that comes out of this, and I think you'll see it in this actual scenario, was the parties came into court and had a list of this needs to happen, and these are the time frames for it to happen. And you look mom and dad right in the face and say, okay, we're at the end of the game. Either you're going to get it or you're not. And we're setting a deadline for reunification. I'm setting the current plan as adoption still. If we're not here by this date, you don't get another pass. Okay? We're going to switch it that way.
Do you see any duplication between this and the case planning process? I guess I'm just thinking in an ideal world, some of this would be handled in a case planning conference. So I guess I'm just wondering what perceived difference, or is it, I'm thinking about in particular the parents, and maybe if they're working and they're already struggling to manage multiple appointments and multiple jobs, how do you then add a case planning conference and visitation, and then you have this process that could take 2 hours to all day?
I've never been involved in a case planning conference, but I felt the same way as the GAL, and I'm looking at what I thought Ceri's report was going to be versus what my GAL report was going to be, and thinking, isn't this redundant? I guess the difference is that at a permanency hearing, you're to the point where these people's lives are going to change. Either the children are going to come back into their home, or the children are going to move on. And this process gives everybody involved in that a chance to effectively deal with how that's going to occur. Mom and Dad see plainly that it is not going to happen. They are not going to have these children back in their home. And they have an opportunity to come forward and say, am I still going to be able to be involved in my child's life? How is this going to work? How can I still give what it is I have to give? In this case scenario, can I still be over at Grandma's house? And Grandma's saying, here's how we could work this so that you're still involved in your children's lives. And from a GAL standpoint, I'm looking at it going, this unification, or this bond that's between the children and their parents isn't just disintegrating. They're still involved. For my kids, they are still getting that sense of family that is so important. So I guess that's how I see it different, that we get all of the parties to buy in, or at least have some input into how this is going to happen. Oh, sorry. Yeah, we'll jump to the second scenario. If I can. In this case, mother has had 3 children. The first child lives with dad out of state. Mother convicted of misdemeanor child abuse on the second child, and a juvenile neglect action was currently filed with a criminal charge. The second child is adopted, and there is a newborn third child born, who is immediately removed and placed in foster care, coincidentally with the prior sibling, the second child. In this particular case, mom ends up going to prison and is in prison, or in jail, yes, I'm sorry. She's in jail, then is released to have this baby and gets to stay out for a considerable amount of time. Mom has been in our system a lot, and we're all very familiar with her. And there is a pretty strong disagreement between the legal parties in this as to whether mom should even have a right to try and parent this third child. I guess when we had the pre-permanency conference in this case, the mother's attorney was coming in saying, no way should we have anything that restricts mom from having her right to parent this child. State HHS is coming in saying, terminate. We've given this mother several chances to try and parent, and she's been unsuccessful in the past. The county attorney is saying, I'm not sure I have the evidence that's necessary to win this appeal, and we all know that's where this is going, so we're talking many months. And GAL comes in and says, wait a minute, I'm not sure mom has had any chance to parent. She's been in jail a good portion of this time, and I'm concerned about it being overturned at this point, and so we start an adoption process that's going to be frozen. In this particular instance, the only parent that was involved and the only family member was the mom. And the pre-permanency conference for us was actually a chance where our mediator helped the legal parties come to a consensus about how to proceed in this case, rather than the parents. And that that shows that it's not just the families that benefit from this. It can also be the legal parties who do have a major part in how long these things go on. Do you want to?
I'd like to say that women, just families can feel like things are stacked against them. And the attorney just felt like the decision had already been made, there was nothing, and he was just there to fight.
Yeah, mom's attorney.
Yes. And guardian ad litem felt like she had not had sufficient chance. There wasn't enough to totally get everything going for TPR. It was a chance to get everybody on the same page. I don't know if that was happening.
I don't think so. And because we did this, what ended up happening was mom, low functioning, had a list of things that we were going to accomplish. We continued this out for the extra 3 months, very specific things. And those things would have given the county attorney the things that she needed if it went up on appeal. And it gave mom a chance to realize, I can't do this. What we ended up having was a voluntary relinquishment. And so, for me, this baby does not have to go through the holding time that the appeal process would have taken and then to bring back down. So, yes.
How vigorously did you pursue the father, identifying the father? Because you have to cross that bridge now. Reasonable adoption. Is that what he suggested?
He said reasonable adoption.
We had a great caseworker. The caseworker and her supervisor is here today. She did a really great job of checking the parental registry for me. She tried to talk to the mother while she was in jail to get her to answer all the questionnaire. The mother was not comfortable with that without her attorney. She provided me an affidavit that I attached to a motion to notice Dad by publication. We know very little about Dad. Through this pre-hearing conference, Mom did give us some more details. I called the county where the child had been conceived, got a very helpful deputy who went through some records, and we thought we had identified Dad. So we call this poor man up on the phone because Jay doesn't want to surprise him.
Right. She's going to just send this guy a letter. And I said,
no, I'm going to send the sheriff out to serve him.
Yeah, and I'm like, no, let's give the poor guy a chance. Call him.
He thinks that we're fraud, and he won't tell us anything, which, in this day of identity theft, I guess was understandable. Then that afternoon, we actually had a hearing, and I went to the sheriff and had him print pictures from the criminal record, and Mom's attorney showed them to her as, no, this isn't Dad. So this poor guy that we've scared the bejeebus out of has never been served by the sheriff.
And now I'm certain he believes that it was a fraud. He even hung up, waited a while, and called my office back to make sure it was an attorney's office. And I was like, who put you up to this?
So I've done my notice by publication. We're set for final hearing. Mom has relinquished her rights. I think that our mediator should be commended for getting us all on the same page, because I think it was actually her idea to say, let's give Mom 2 or 3 more months to show us what she can do after she got out of jail. And we filed a very detailed motion, a joint motion signed by myself as the state's representative, the guardian ad litem, and Mom's attorney, asking to forward that additional 3 months. In fact, I think we had a 2-page motion with a bulleted list of what we were going to do that I drafted and had the other attorneys sign off on, and I think we even made a change to it. But I think that mediation process got us to that point that we could all be on the same page. And yeah, we went beyond our 12 months, but we had good cause.
So you're terminating the father's parental rights by publication?
Yes.
For abandonment?
Yes.
Now, if you by chance will do the adoption, and sometimes guardian ad litems do, you've got a child born out of wedlock. You've got to go through that process now with the father being appointed as an attorney, and you've got some proof for it.
Yeah, and we really, to say due diligence in trying to locate this father would be an understatement, because we were actually going, okay, do you remember what town it was in? Do you remember whether you crossed railroad tracks? Do you remember, you know, who was living in the area, things that you drove by. So we really did get into detail about how that could happen. And then with Charlotte going to the sheriff and saying, okay, so, you know, who do you know that was in your jail during this time that went by the name of Jose or whatever? And so we really did do the due diligence. I feel like that's one that we could really show that we made every effort to attempt to contact him.
And that was the other side of building the case that I could win on appeal, is that we did notice, we did everything we could to notice a dad that we know very little about.
We are way past our time. Thank you very much.